Hello everyone and welcome to a fresh episode of Legal Wrangle on Corporate Laws. Today, we have 6 interesting cases for you ranging from Companies Act, Trademark Act, competition laws and also SEBI orders. Let us begin with the much talked about judgment of the Bombay High Court relating to the defamatory statements made by Mr. Azim Premji for Subiksha Trading Services. The company claimed that the statements made affected its business drastically. Azim Premji challenged Subiksha's suit on the ground that the board resolution authorizing company's promoter cum MD to file legal suit was not in compliance with the company's articles. Shalu brings the facts.
The plaintiff Subiksha Trading Services Limited wanted to revive its business with financial assistance of various banks. Subiksha alleged that due to defamatory statement made by Mr. Azim Premji, banks were reluctant to support its revival. Hence, it filed suit through its promoter cum managing director before the court stating it had suffered a huge loss. Mr. Azim Premji challenged the maintainability of the suit on the ground that Subiksha's promoter cum managing director had no authority to file the same, as according to the Article of Association, any resolution for commencement or discontinuance of any litigation required the consent of at least one director nominated by the venture capital investor ICICI Trusteeship Services Limited, and its consent was not taken.
The court dismissed the suit for want of authority of Subiksha's promoter cum managing director filed the same on behalf of the company, as the alleged defamatory statements were extremely material in the context of Subiksha's business, and litigation of such kind could not be started without complying with provision of Articles of Association of the company, which required the consent of at least one director nominated by the venture capital investor. Let us now move to very recent order passed by SEBI for not complying with collective investment schemes regulations and failing to refund investors' payments. Here comes the facts.
The appellant in this case was Alchemist Infra Reality Limited, which was operating collective investment scheme without obtaining registration from SEBI. SEBI passed an order directing Alchemist to wind up the scheme and refund the money to the investors. The company approached SAT and then the Supreme Court, which upheld the SEBI order but extended the timeline for refund from 3 months to 18 months. Alchemist submitted several reasons for not being able to complete the refund process within the time granted and sought further extension. An auditor was appointed to undertake the verification exercise for refund, but Alchemist did not cooperate. SEBI came to know from the Income Tax Department that money refunded by Alchemist were routed to a group company, namely Alchemist Township India Limited. SEBI issued show cause notice to Alchemist. The company requested for 24 months time to make refund to all the investors.
SEBI found that the provisions of Regulation 73 were not applicable to the schemes of the Alchemist. Consequently, the draft information memorandum filed with SEBI was declared void ab initio. Hence, all the applications filed by the Alchemist were rejected and attachment and recovery proceedings were ordered. From the basket of IPR laws, we present 2 cases relating to the Trademarks Act. The first case relates to the squabble that arose between 2 cement companies, namely Ultratech Cement Limited and Dalmia Cement Bharat Limited, over the use of the word Ultra. The Ultratech Cement alleged that Dalmia Cement Bharat had resorted to use of its exclusive trademark with a view to establish a false nexus with its business and to trade on their reputation. Let's take a look on the facts first.
Ultratech Cement Limited was a registered proprietor of several trademarks containing the word Ultra, such as Ultratech Cement, the Engineer's Choice, Ultratech Concrete, Ultratech Readymax, etc. Ultratech Cement came to know about Dalmia Cement's use of mark called Dalmia Ultra, containing as their essential feature the word Ultra. In an application submitted for registration of its mark Dalmia Ultra, it was claimed by Dalmia Cement that the word Dalmia was being used by them since January 1939, while the word Dalmia Ultra as a whole is merely proposed to be used as on the date of the application. It was also argued by Dalmia Cement that Ultratech's registered mark are all label marks containing the word Ultra as only one of the marks, and they cannot statutorily claim any monopoly for any particular part including the word Ultra.
The court observed that the word ultra is a common English word mostly used as a prefix and cannot be described as an essential feature of the Ultratech Cement's mark, affording it a monopoly for its use. The court pointed out that the prominent feature of most of the Ultratech Cement Limited registered trademarks is the word Ultratech and not the word ultra per se, and even when the word ultra appears in its registered trademarks without the word tech, it is mostly used as a prefix and never as a standalone or as a prominent or essential feature. Accordingly, the court pronounced that the trademark ultra, which is always used in combination with other terms, is not distinctive enough to grant monopoly rights to the plaintiff so as to injunct others from using it in some other distinguishable combination. What would happen if the owner of a trademark inadvertently fails to renew the same? Would it amount to abandonment of the trademark? And what would happen if some other person knowingly usurps a trademark of another, deriving benefit from the goodwill of another? Can such person take the defense of acquiescence? All these questions are answered in our next trademark case. Let's find out the facts in detail.
The case was filed by BCH Electric Limited against Eton Corporation and its Indian subsidiary Eton Power Quality Limited. Eton contended that the trademarks Cutler Hammer, CH Level and CH Control were first adopted by Cutler Hammer, a predecessor of Eton Corporation. However, these trademarks could not be renewed due to non-deposit of renewal fees. Cutler Hammer Inc. floated another JV company in India which was renamed as BCH Electric. The JV was also terminated subsequently, barring a few ancillary relationship agreements in the term of which BCH Electric was granted non-exclusive right of use of such trademarks. Thereafter, BCH applied for registration of CH Control black trademark, to which Eton did not object. Then BCH Electric filed an application for registration of the trademark Cutler Hammer, and this time Eton filed a notice of objection against this application. BCH Electric claimed that it had used trademark CH Control, Cutler Hammer and Bhartiya Cutler Hammer for several years and had acquired rights in the said trademarks. Eton and BCH Electric engaged in tussle wherein interim injunction application filed by Eton was approved by the court. Aggrieved by the same, BCH Electric moved to the High Court.
As per the agreement between Cutler Hammer and BCH Electric, a mere right of use of the trademark was allowed, and it was agreed between them that BCH would not claim any rights in the specified trademarks and the trade name of Cutler Hammer. The court observed that when Eaton did not renew the trademarks CH Control and CH Label, it did not indicate that Eaton had abandoned its trademarks. The court also pointed out that BCH Electric did not refrain from using the trademarks as it was obliged to do under the agreements, but continued to trade on to the goodwill associated with those trademarks. When Eaton did not object to such use, it did not constitute BCH as the owner of trademarks, and any endeavor to claim their ownership would prima facie amount to usurping Eaton's property. Accordingly, the High Court dismissed the appeal. Now, we are going to deal with a very important order of Competition Commission of India, where group companies having parent-subsidiary relationship were operating in the upstream and downstream market, with the parent company being a dominant entity. The key question was whether there was abuse of dominant position by parent company when the subsidiary company was given an undue preference in the downstream market. Here are the brief facts.
The informant XYZ Limited accused REC Power Distribution Company Limited, wholly owned subsidiary of Rural Electrification Corporation Limited, for leveraging its association with it for work-related consultancy services in relation to some rural electrification project, mainly preparation of detailed project report. It was alleged that REC Power Distribution was securing orders on the basis of its verbal promise that it would get easy, faster approval from its parent company. Based on project report, work as allotted to REC Power Distribution without following tendering process. Competition Commission of India ordered investigation by DG in this matter. DG concluded that a parent company, Rural Electrification Corporation Limited, was clearly in a dominant position in the market of financing of rural electrification project in India under Rajiv Gandhi Gramin Vibhuti Karan Yojana scheme and conduct of REC Power Distribution and its parent company as a group resulted in denial of market access to other participants in the relevant market.
The Commission did not find any conclusive evidence to indicate that the preferential advantage was given to the REC Power Distribution in relevant market. It was held that in the absence of any sufficient evidence on record, the conduct of such group cannot be said to have resulted into denial of market access to other consultancies who were the competitors of the REC Power Distribution in the relevant market for preparation of detailed project reports for projects under rural electrification schemes. In order to establish a case for leveraging under the Act, there should be a conduct on the part of the dominant enterprise to demonstrate the use of dominant position to enter into or protect another relevant market, which was missing in given case. Now we take up the last case of this episode, where SEBI has come across persons and entities who, by making use of fake bulk SMS, lured investors to buy stocks of one particular company, resulting in price manipulation and fraud. Let's go into the details of the case first.
The Bombay Stock Exchange received complaints from investors about fraud done to them by use of bulk SMS. Based on the stock tips received, investors bought stock of Dhyan Fin stock, after that unable to sell the stocks on the same day because of the scrip being in trade. Further, on the next day, the scrip opened at the lower circuit. BSE, after inquiry, suspended the company's trading. In process of revocation of suspension, it asked Dhyan Fin stock to submit certain document, but the company did not cooperate. Hence, matter was with SEBI for necessary action.
SEBI barred the net sellers who were identified as preferential allottees from accessing the securities market from buying, selling or dealing either directly or indirectly. Not only this, to avoid the misuse of sale proceeds of the trade, SEBI further directed BSE to continue to withhold the same till further directions. With this, we wrap up this episode of Legal Wrangle on Corp Laws. Thank you for watching.